My name is Michele Ferroni. I'm a criminal defense lawyer. You want to know about expungements? An expungement essentially is a dismissal of a prior conviction. It's pursuant to 1203.4 of the Penal Code. And what it allows is certain individuals that have been convicted of, let's say, misdemeanors, infractions, wobblers, which are felonies that could be reduced to a misdemeanor, people that have been convicted of a felony but have not served any state prison time. It allows them, after their probationary period is done, to go back and file a petition pursuant to 1203.4 of the Penal Code to have their case dismissed. When I say dismissed, I mean that a court will allow them to withdraw their plea, vacate their conviction, and reflect a dismissal on their record. Now, one of the myths about 1203.4 expungement is that typically a client will think that it's just going to go away, that nobody can see it, that they no longer have a criminal record. And I get that a lot. And what I tell people is that no, you still will have a record. And if somebody were to look it up, what they'll see is the process that you went through, that you were arrested, you were charged, you were convicted, and then at some point a judge granted a relief under 1203.4 where the case was dismissed against you. Now, one of the benefits to the 1203.4 expungement is that if you're ever completing a job application or talking to a prospective employer, you can legally say that you have not been arrested, charged, convicted of that particular crime. However, there are some caveats to that. Typically, on a state licensing, you have to admit that you have been convicted of the crime. However, it does legally give you a lot of opportunities to say that you have not been convicted of anything. I think that in order to seal or destroy an arrest record is pertinent in medical marijuana cases. The reason being is that that particular vehicle only applies to somebody that has been arrested for a crime. They may have been charged with a crime, but ultimately not convicted of a crime. It happens when the prosecution either rejects the case and doesn't file it, or at some point during the proceedings, the case is thrown out by a judge. What that individual needs to do is, subsequent to those proceedings, they need to file an order to seal or destroy an arrest record. And the criteria that is used for that is that they're factually innocent of the charges. So if a case is rejected because the district attorney or whatever prosecuting agency it is decides that this person did not commit this crime, or when they're into proceedings and a medical marijuana patient uses their recommendation as an affirmative defense and a court decides that the person is not guilty and factually innocent of the charges, they will want to go back later on and file this petition to have their arrest record sealed and destroyed. Otherwise, the arrest will stay on their record and there would be no way to eliminate it unless they take the steps to do so. With an expungement, a person's criminal record does not go away. In the instances where an expungement is sought, typically a person has been convicted of the crime. However, after successful completion of probation, if they've not been to state prison and they otherwise qualify, a judge will go ahead and allow them to withdraw their plea, vacate the conviction against them, and dismiss the proceedings. I think it's a good tool because nowadays, especially in this economy, with work being very difficult to find, it allows a person to not have to put their criminal record on their job application or to answer to a prospective employer that they've been convicted of anything. If somebody were to look at the record, it would state the arrest, it would show the charges, it would show the conviction, and would show the proceedings were dismissed against you. which I think goes a long way, especially as I mentioned in this environment. The petition to seal or destroy the record is pertinent to only individuals that have been arrested and not convicted of anything. They can be charged but not convicted of anything. And as I mentioned, in those proceedings, a court would have to find them factually innocent of the charges. It's a very difficult threshold, but certain cases will mandate that, especially in medical marijuana cases. And in that particular instance, there will be no criminal record. At some point, if the order is granted, the record will be destroyed and it will be sealed by Department of Justice and whatever arresting agency made the arrest in that case.